everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the most important form least used in the contract packages. What is that form? Well, I'm not going to make you wait. That form is the notice form, and in the GAR contract packages, that form is F816 called notice. And in the RE forms packages, it is called notification, and it is RE260. Why do I say this is the most important form that is the least used? I'll tell you why. In the contracts, whenever it has the word notice, there are specific ways in which the buyer and the seller must communicate. And what happens all too often is you, as one agent representing one of the parties, simply sends an email to the other agent. Well, that's very informative for you guys as agents, but that does not satisfy the terms of notice per the contract. So it is the same information in the RE forms, but let me read you how to send notice in the GAR contract package. It is defined in the contract. And if any of y'all have ever heard me, been in any of my classes, you will have heard me say that the contract is nothing more than a set of instructions that tells you what to do and how to do it. So let me find, let me read to you what it says about notice. And again, I'm just going to read it from the GAR contract package. In the RE forms contract package, this is all spelled out in the standard terms. So in the GAR purchase and sale agreement under paragraph C1, it talks about notices. And basically it says that all notices must be in writing, legible, and signed by the party giving the notice. You as agents are not essential agents to the contract. So the party giving notice must be the buyer or the seller. That's why I say agent email to agent email. You don't have the signature of the buyer or the seller, so you're not fulfilling the terms of notice per the contract. It goes on to say that the party giving notice is the burden of who gave notice is to prove delivery. Now, there's more information about that. Basically, you can send notice to by courier, U.S. mail, return receipt requested, so forth and so on. It must be to a physical address, or it can be done electronically to a fax number or an email address. But it goes on to say that that fax number or email address must be that as noted on the signature page of the purchase and sale agreement. So agents, if your contracts auto-populate with a fax number from your company, remember that is typically only monitored Monday through Friday, 9 to 5. So you could get notice to that company fax number after 5 o'clock at night or on a weekend, and you're never going to know it, but it will have satisfied the terms of the contract. So if you're not comfortable with that, make sure to take that off of the signature page of the purchase and sale agreement. You only need one of those three forms of notice. The contract goes on further to say that if you are working with the public person as a client, that notice to the agent or broker does serve as notice to the client, and that includes delivery to a staff person at the office. Now, here's the thing with electronic notice. So typically we think of that as email. Email is electronic notice. It says in the case of delivery electronically, then notice is deemed received by the receiving party on the date and time the written notice is sent to the email address or fax number of the party. So the burden is on the sender. So if you are the receiver of a notice from one of the parties, then it doesn't matter when you open up that email. What matters is when the party that sent the notice can prove they sent it. And why do I say this is important? Well, for example, let's just look at, let's go back here and look at the purchase and sale agreement. So in the purchase and sale agreement, where it just as an example, there are several examples throughout the contract, but as an example under paragraph B1B, where it talks about the buyer may examine the title and obtain a survey. And then if there's any objections to that, the buyer must furnish the seller with a written statement of title objections. And if you find out from the closing attorney that there's an issue with the title, an agent email to another agent email does not serve the form of notice of the buyer sending written notice with their signature to the seller that we have an issue with title. And it goes on to have termination rights, but you have to fulfill the first part of that notice. Here's another example. In the backup contingency exhibit, it states that in the event the primary agreement is terminated, so this is a backup contingency. A buyer and a seller are contingent. There's a first primary contract, and this is a backup contract. You're binding with this backup contingency exhibit. And it states that in accordance with the terms of the conditions, notwithstanding, shall be the date that this notice of the termination of the primary contract is delivered by the seller to the buyer. So in other words, that's when all the dates for the backup contract, that would be day 0. But again, an agent, the listing agent sending the agent to buyer number 2 an email saying, hey, the first contract fell through, you're now in primary position, that does not satisfy the terms of notice per the purchase and sale agreement. So what do you have to do? You need to use those notice forms. That's why I say it is the most important form that is used the least. So you would use GAR F816 notice, and you fill out, is it the buyer or the seller that's giving notice? In this example, for the backup contingency, it would be the seller giving notice to the buyer, and you would simply state that per backup contingency exhibit D or whatever exhibit you have it referenced, seller hereby gives buyer notice that they are now the primary contract for the purchase of this house. And then on that notice form, there is a place for the signature and the date of the party giving notice. And then you must email it, send it to the address, or fax it to the other party. That date that the party sending the notice can prove they sent it, that becomes day 0 in this example for these purposes. So again, you guys, what happens all too often is an agent sends the other agent an email, and nothing's an issue until it's an issue. But if it's an issue, would you be able to prove that you sent notice? No. Email to email communication between the agents are not the essential parties to the contract. And let me show you where that is talked about. Again, in the GAR purchase and sale agreement, under under more of the definitions, under paragraph C, it does talk about, hang on one second and I will tell you what it talks about. It says, no authority to bind. No broker or affiliated licensee of the broker by virtue of this status shall have any authority to bind any party hereto to any contract provisions herein, amendments, terminations, so forth and so on. However, if authorized by this agreement, the broker shall have the right to accept notice on behalf of the party. Additionally, any broker of a real estate licensee involved in this transaction may perform the ministerial act only of filling in the binding agreement date. In the event of a dispute over the binding agreement date, it may only be resolved by written agreement of the buyer and the seller. But again, you guys cannot bind the party to terms. So agent-to-agent communication does not satisfy the terms of notice as defined in the purchase and sale agreement, under the GAR form, and in the contract, the standard terms in the RE forms. So again, just sort of a little hint, a little contract tip, but it's not really little. It's very important to be able to prove that it is the party that sent the notice for something to happen in the contract. Every time it talks about notice, it must be in writing and signed by the party. So I hope this contract tip helped you guys out. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.